All right, it's 9:01. We're going to go ahead and get started. So good morning, everyone. Hello and welcome. Thank you for joining us on this very rainy morning. My name is Elizabeth Seeger. I'm CDT's Communications Manager and point of contact for press. In today's On the Record briefing, we'll be talking about the relationship between the modern digital world and the reproductive rights of people in the U.S., particularly as we approach the one-year mark of the Supreme Court's decision in Dobbs. Today, you'll hear from Alexandra Givens, CDT's President and CEO, Andrew Crawford, Senior Counsel with CDT's Privacy and Data Project, and Jake Laperruque, Deputy Director of CDT's Security and Surveillance Project. The plan today is to run for about 20 minutes, and then we will turn it over to Q&A from the audience. You can submit questions to press@cdt.org or by using the Q&A feature in Zoom. You can also reach out after the briefing to press@cdt.org with any questions about reproductive privacy. As always, you can find me at press@cdt.org, where the rest of the CDT Press team is also available. We're always happy to answer inquiries there. Just reach out. So with that, I will pass it to CDT's President and CEO, Alexandra Givens. Thanks, Alex.
Great. Thanks so much, G, and thank you everyone for joining us today. We're particularly glad to have this briefing as we ramp up to the one-year anniversary of the Dobbs decision this weekend. And one of the things that we're prioritizing as an organization is just how much these issues touch on the technology sphere and the way that we use technology across the course of our daily lives. I'll talk a little bit about CDT's work on this, and then you'll hear from two of our subject matter experts, and then we'll come back to me for a deep dive in different areas that we focus on. As it became clear where the court was heading in the months leading up to the Dobbs decision, and then after the decision finally came down, CDT quickly realized just how much tech issues were going to be at stake in the implementation of that decision and in the course of people's daily lives. One of the things that we focus on a lot is how in our modern world, information that we share throughout the course of our daily activities can reveal incredibly sensitive information about our health and about our healthcare choices. Just to give some examples, think about the information that you share when you are browsing different websites, for example, the information that you share when you put a search into an online search engine, the location history that's collected by your phone, by various apps on your phone, various devices, and of course, the content of messages as well when they're not encrypted, shared between loved ones, or even the content that you put into something like a period tracking app or other types of information services. We've also thought a lot about how even things like marketing pixels embedded on the websites of healthcare providers have been found to share information with major social media companies, again, who are collecting these types of information for purposes of ad targeting, but in so doing are able to just cast a dragnet and really access very sensitive information about people's lives. This is not just the hype machine and speculation. Even before the Dobbs decision came down, we saw prosecutions based on this data. And in the light of the Dobbs decision, with an increasing number of state laws, both criminalizing abortion care and things like aiding and abetting abortion procedures or access to abortion, we realized that not only were we going to see this type of information being used in prosecutions, but also in private lawsuits as well, by kind of so-called bounty hunters who might be bringing cases or investigations against people who are either seeking or providing services. This tech landscape is then therefore going to significantly impact people's lives. We also realized that this is going to be an issue for the tech companies. They are going to be right in the heart of an incredibly politicized debate. And again, we have seen that bear out over the past year. Many of you will remember last summer when Facebook was embroiled in a prosecution against a Nebraska woman based on the private but unencrypted Facebook messages between her and her daughter. She ultimately helped her daughter purchase medication to obtain an abortion. And suddenly these companies are in the crux of these and looking to navigate, we hope, how to handle that landscape responsibly. So CDT formed a task force immediately after the decision, and it pulled together a whole bunch of reproductive rights organizations, health data privacy experts, civil liberties experts, former prosecutors, and tech and telecom companies navigating these issues. And over the past year, we've kind of created a place for information exchange and for people to understand different folks' experiences, gather and share experiences. We've also put out a bunch of recommendations and done work in different advocacy areas, which we think of in three categories. The first is commercial data privacy practices. So the ways in which companies now amass highly sensitive information about users and what they do with that information, what the best practices should be to limit how much of this information they are collecting, storing, sharing over time. The second big theme for us is law enforcement. So this is how law enforcement is able to access that information, what protections are in place, how companies navigate those protections, and also how some states have been able to step up to heighten protections from law enforcement investigations. And the third set of priorities is around access to reliable information online, which we'll touch on today because that's another area that has also been under attack. So today you're going to hear really short presentations on each of those three buckets: commercial privacy, law enforcement access, and then access to reliable information online. And we're happy to take questions afterwards. So Andy, I think I'm passing first to you to cover commercial data practices.
Thanks, Alex. And hi, everybody. I'm Andy Crawford. I'm a senior policy counsel on the Privacy and Data Project. And a lot of my work focuses on commercial data practices and how they overlap with health data. So health data has long been considered private and personal. Connecting with your doctor, looking for health information online, or tracking your health on your smartphone can all feel very private. But companies collect information about your activities, and sometimes they use it to target you with ads, for instance, and sometimes they share it with third parties, including data brokers. The federal law to help keep health data private, the Health Insurance Portability and Accountability Act, we all know it better as HIPAA, was passed back in 1996. But as time has passed and the internet has grown, the technology has quickly outpaced that law. And it's become abundantly apparent that HIPAA's privacy protections fail to cover a vast new universe of health-related data that companies now collect. As Alex alluded to, we now have apps that do a myriad of things around health. Things like they track your diet, they track reproductive cycles. You can use apps to better your fitness outcomes by tracking workouts. You can track your BMI, you can track your blood pressure, and on and on and on. And most of these apps and services are not provided directly from or by your doctor or your insurance company. And as a result, they're not covered under HIPAA and instead fall under general privacy protections that are mostly governed by the jurisdiction of the Federal Trade Commission. In the wake of the Dobbs decision, there's been a renewed focus on how these points of information could be used by law enforcement or private individuals seeking to sue or target people for seeking or providing abortions and other reproductive health care. As we've alluded to, that data can often come from companies that develop apps and websites and location trackers. So one way to better protect the privacy of data, especially sensitive data about our health, is for companies to just limit the amount of data they collect and eliminate data they already have. And that's where CDT's recent Data After Dobbs report comes into play. In the post-Dobbs era, companies must play a more active role in protecting their consumers' and users' private information. And our report details how and outlines best practices for companies to do this. Our Data After Dobbs report is intended to be a practical guide for companies and their decision makers, their product designers, their developers, and advocates and concerned customers to understand the privacy concerns inherent in many data collection practices and how companies can act. We've also seen action at federal agencies and their efforts to limit the sharing of reproductive health data. For instance, in April, the Department of Health and Human Services, Office of Civil Rights, proposed new rule changes that would limit law enforcement access to patient data. These proposed changes are designed to prohibit the use and disclosure of people's reproductive health records for criminal, civil, or administrative investigations or proceedings against people for seeking, obtaining, providing, or facilitating reproductive health care that is lawful in the circumstances under which it was provided. CDT filed comments that we just filed on Friday, commending HHS for taking this action, and our comments included several additional suggestions to further strengthen HHS's proposals. In sum, our comment focused on ways for HHS to further limit the sharing of all data that reveals people's reproductive health care And we also call on HHS to place powerful limitations around law enforcement access and the use of people's medical records. So I'll pause for now. I'll turn it back to Elizabeth, and I look forward to answering your questions.
All right, thanks, Andy. Next up, we have Jake Laperruque, who is the Deputy Director of CDT's Security and Surveillance Project. Jake, take it away.
Hi, everyone. So, since the Dobbs decision, we've been very concerned with the idea of abortion surveillance. Obviously, in general, that's going to be an important aspect of enforcement of bans, and we think it's especially going to be compared to the past, where, as we've spoken of reproductive rights groups, most enforcement was through doctors themselves. Basically like reporting out patients or reporting out each other. But now, given the proliferation of medication abortion and other techniques that are just harder to track, we think that it's very likely in the future that trying to push for deterrence and punishment is going to be a much more common method of enforcing these bans, as opposed to sort of the preventative side and person-to-person interactions that existed before Roe. So two particular types of issues around abortion surveillance that we've been pretty focused on and think continue to be quite important. The first is shield laws. Now, there's you'll hear the term shield laws thrown around a lot in this space. It can mean several different things. For us, shield laws don't just refer to those types of instances when states have enacted policies saying we're not going to cooperate to prosecute someone who performed an abortion in our state that's legal, even if it's illegal out of state, or provide reproductive health care or cooperate with those investigations, but actually sort of proactively prevent companies from complying with warrants and subpoenas for abortion investigations based on activities that are entirely out of state. So, for example, California banning a California company from complying with a warrant or other court order from a state like Texas regarding a unlawful abortion that occurred entirely in Texas. Now, there are a few states that have passed shield laws. I mentioned California as the example because last fall they were the first state to do this. They enacted a law that prohibited any California communications provider or remote electronics company from providing, from complying with warrants, subpoenas, or other court demands for investigations into reproductive health choices. So that means companies like Apple, Google, Facebook, these companies are all prohibited from, if they get a warrant or a subpoena that's about an abortion investigation, they are by law, California law, prohibited from complying with that, even if the procedure and relevant conduct occurred entirely outside of the state of California. It effectively bans them from engaging in those investigations nationwide. So that kind of set the standard last fall. Since then, we've seen some more recent action. Last month, both Washington State and New York passed shield laws of their own. So with those combined effects, I think we've now reached the point where most major email and electronic communication providers are bound by these shield laws. So far, we haven't seen indicators that these types of shield laws have actually proved necessary, that demands have been coming in to these companies, but we expect it's certainly just a matter of time before they do, and that there'll probably be a pretty rigorous conflict of laws dispute when it does. So we think it's definitely an important space to follow. After Dobbs, there were a lot of questions about how are things like your emails, your text messages, your DMs going to be potentially weaponized for abortion surveillance. We think that's certainly still a very serious threat, but these shield laws, we think, also could provide a significant impact in stopping those kinds of investigations, or at least stopping that type of surveillance of being part of those investigations. So shield laws is the first area we've really focused on. The second one is the idea of federal aid. We're very concerned with the notion that federal aid to state and local law enforcement could be co-opted for abortion surveillance. And we think that this is something that the administration should be concerned with as well, because they've expressed a strong desire to try to protect reproductive rights and reproductive choice. There are a number of ways that the federal government, however, supports surveillance by state and local law enforcement. Some examples we've written about in the past include regional computer forensic labs, the FBI's Computer Analytic Response Team, and the National Domestic Communications Assistance Center. Now, all these entities basically provide state and local law enforcement with the means to conduct or facilitate surveillance that go far beyond the resources that local law enforcement would have. It helps break into encrypted devices. They can help provide access to standard warrants and other types of orders that you might want to send out that could take tons and tons of time to draft up if you didn't have these sort of boilerplates done already. It helps dissect data that comes in potentially unreadable form in terms of lifting out location data, IP and web browsing data, et cetera, things like that. So really just amplifying the power that state and local law enforcement have for investigations. Now, last December, over 50 organizations, civil rights groups, civil liberties groups, reproductive rights groups, called on the administration to act on this issue and to basically shut down use of these resources for abortion investigations. And it's not just groups. This year in February, over 30 Democratic senators and representatives sent a letter to the administration with a pretty similar demand, calling on them to ensure that no federal aid to state and local law enforcement could be used to support investigations into reproductive health choices. Now, so far, we haven't seen any action on the administration on this part, which I think is disappointing. But I think this is definitely another area that's going to be ripe to keep along with. I think it'd be really valuable for reporters to look into our states and localities that are prosecuting reproductive health choices, making use of the type of federal resources that I mentioned before, both in general and specifically for investigation of abortion and reproductive health choices. What is the administration's view on this? What is their plans for action? And are there cases where we've seen reliance on things like email, getting into computers, getting into phones that could be strongly aided by these types of federal aid, where state and localities pressing for abortion bans would want to see action on and would want to use these resources. So that's kind of our second big focal point, is the overlap of federal aid and abortion surveillance. So those are the two big areas on surveillance that we've been focusing on, and will be continuing to do so, and think are probably areas worthy of a lot of scrutiny from the media.
Right. Thank you so much, Jake. We will have Alexandra Givens, our CDT's president and CEO, just make a few other remarks, and then we'll turn it over to Q&A.
Great. Thanks, Dee. So I'm going to pull us back to the third area of focus that CDT has been working on, and that we hope the press will be paying attention to, which is around access to reliable information about abortion and reproductive care online. We're looking at kind of three big subject matter areas in which this is coming up. The first is legislative efforts that would limit access to information about reproductive care. We've seen pro-life groups circulate model legislation that includes making it illegal to share information online about obtaining abortion pills, for example. Many of you will have noted a piece of legislation introduced in South Carolina last summer and Texas this spring, each of which try to make it unlawful. In the case of South Carolina, make it a felony punishable by up to 25 years in prison to host a website that provides information on how to obtain an abortion. The Texas bill would make it unlawful to create, edit, upload, publish, host, maintain, or register a website that assists or facilitates a person's effort in obtaining an abortion-inducing drug. These pieces of legislation have not moved forward. In the viewpoint of CDT and many others, they're patently unconstitutional, and we've seen people actually on both sides of the aisle raise concerns with the First Amendment implications of these bills. But they're an interesting trend to watch, in part because the rhetoric around it does increase pressure on how social media companies think about their content moderation policies in these issues. So we're going to be watching these bills, see whether any of them do move forward, and kind of keep that as one space to watch. Another area in which legislation is important to pay attention to are a couple bills that do not focus specifically on access to information about abortion, but that would have significant effects for access to such information. There are two that we are most focused on. One is the Texas social media law, HB 20, which is currently being litigated all the way up through the Supreme Court. The Supreme Court is waiting for the views of the Solicitor General on whether it should take up a case challenging the constitutionality of this law. This is a law that mandates that social media companies moderate content in a way that is viewpoint neutral, an idea that is quite, appealing on its face, but when you dig a level deeper, would have significant impacts on the freedom with which social media companies can moderate online content, including online content that they find troubling or violative of their terms of service. So a number of groups, and CDT is one of them, have raised concerns about how that legislation would make it harder to police hate speech and harassment, information about suicidality, pro-terrorist content, for example, because again, you have to be viewpoint neutral in how you address and moderate content on these issues. And then also how it might impact companies' ability to moderate, in particular, mis and disinformation about reproductive care. So that's shown up in some of the briefing around this bill as it has moved up through the courts. And we are waiting now to see if the Supreme Court will take up the case challenging the constitutionality of this law in the net choice case later this year. Another piece of legislation is at the federal level and may be on the beat for some of you, which is the Kids Online Safety Act. That is a piece of legislation that has been moving its way through Congress with bipartisan support. Again, very well motivated in terms of its intentions here, but again, with unintended consequences that CDT and numerous other civil liberties, civil rights organizations have been cautioning about. The concern that we've been raising about the Kids Online Safety Act is that it creates a duty for social media platforms to prevent and mitigate harms to minors enforced by state attorneys general. So the point that we've been making in a world where some state attorneys general view access to information about reproductive care or access to information about gender affirming care for that matter as something that teenagers should not see, we believe that this bill could easily be misused for politicized campaigns to stop the social media companies making this information widely available. And so that is another space to watch and another kind of lens on this online safety movement that is happening in Congress to think about these unintended consequences for access to important health-related information for people looking for information about access to reproductive services. Another bucket of area to focus on is about access to reliable information and the concern about people's privacy, doxing, for example, if they're accessing websites that purport to give information about reproductive services, but might actually be redirecting them. Crisis pregnancy centers, some fear might use this technique, or God forbid, doxing people or gathering their private information because they are trying to find information for abortion care. The FTC has issued a warning about this. They published it last summer, so we congratulated them on that and have been spreading the word about it. It's also something that we believe that companies should be focused on. A number of them have announced policies in this regard. So, for example, Google has talked about if you search for an abortion provider, they are careful and actively monitor what ads can show up against that search, that it actually needs to be an abortion provider who can run ads against that search. But some journalists have raised real concerns about whether or not that policy is actually being followed in practice. And we think that's another really important area to watch. If there are sites that are found to be doxing, how quickly are the companies responding? How quickly are they taking them down? And is the FTC bringing action? Those are the types of issues that we want people keeping an eye on. And then the third and final one that we'll talk about is enforcement of content moderation policies. So here, the big question is how social media companies are enforcing their content moderation policies at a time of very significant pressure, in particular from anti-abortion state attorneys general about the access to this type of information. There are a number of abortion groups who feel like their posts are being taken down. No, I think so far there's still work to be done documenting that, but they are observing in their own experience that they're having a hard time creating the reach that they did. There was a series of news stories last year about whether ads for abortion medication are hosted on social media sites or not. And when they were being taken down, was that targeting because it was abortion-related medication, or because the companies were enforcing their policies about not allowing ads for any type of medication on their services? So that's kind of one area to watch, is how these content moderation policies are being enforced. There's a particular news hook on this right now because the Oversight Board has just taken up 3 cases all about abortion-related speech online, on Facebook specifically. What's interesting about these is that they actually all are coming up under the incitement to violence policy, is how Facebook adjudicated them, because they involved people using violent language or threatening language in describing or attributing viewpoints to the other side in the debate. So, for example, one of the cases of the 3 is somebody who posted a news article about South Carolina's law criminalizing abortion and characterized it as "will kill you dead if you get an abortion." So Facebook's initial filter viewed that as "will kill you dead" as a threat, and the content was taken down. The Oversight Board is considering whether that's an appropriate interpretation of the incitement to violence policy, or whether this is actually more expressive conduct, describing a news event. So that they are taking public comment on that Oversight Board case right now. It should be heard pretty soon, and that's another area that we'll be watching too. With that, I will pass it back to E for Q&A. Thanks.
All right. Thanks, Alex. That was Alexandra Givens, CDT's president and CEO. So with thanks to Alex, Andy, and Jake, we'll now turn it over to a question and answer session. So we have a few ways that you can submit questions. The first and the easiest is via the Q&A feature in Zoom. And the second is via email to press@cdt.org, which may be particularly helpful for folks on the phone. So with that, I will go ahead and open the floor to questions. All right, we have one. So have we seen any cases involving tech yet?
Sure, I'm happy to jump on this, and then Andy or Jake, you should feel free to as well. So before the Dobbs decision, we saw a number of pregnancy-related prosecutions using people's private information gathered from their devices. So there were prosecutions that used people's online browsing history or their search history as part of the evidence, as well as payment records as well. And as well as the contents of their text messages. Since the Dobbs decision, there have been a couple high-profile cases so far. One is the Facebook Nebraska case, which I mentioned, which again, one of the main sources of evidence were the Facebook messages exchanged between a mother and daughter, which were private but not encrypted, and the company was forced to hand those over. In the messages, the mother and daughter were talking about how to purchase abortion medication online. And then a second one that's kind of taken national attention came out of Texas this spring, where an ex-husband sued his wife's 3 best friends under the private lawsuit provisions of Texas law for helping her access abortion medication or give her advice on how to access abortion medication online, using, again, the evidence of text messages exchanged between them. To my knowledge, there have not been others widely publicized in kind of the national eye, but there are a couple of reasons why that might be. One is sometimes these cases just take time to percolate through the system. 2, as Jake will be able to talk to in more depth if people have questions, often when law enforcement is pursuing this type of information from a company, so they're coming for people's records from a third-party holder of that information, it's accompanied by a gag order, which means that the company is not able to reveal that they've received that law enforcement request. And sometimes when they receive those requests, they don't even know that it's connected to an abortion-related prosecution. So either there might not be kind of the actual specifics of the crime alleged at all, or it might come under a child endangerment or a murder charge or something along those lines that makes it hard to know exactly what the fact pattern is. So to our knowledge, I think those are the 2 that have definitely come into national prominence the most.
All right. Great. Thanks, Alex. And then we have another question. Some states have complained that federal agencies are overreaching past their federal powers in abortion regulations. Are you concerned that federal protections may be overturned in litigation between states and the administration?
So Andy, why didn't you jump in on that one? I interpret that as thinking mainly about the changes to the HIPAA privacy rule, and I think you can make a good, give a good response there.
Yeah, exactly. That's where I was going to take it to. So thanks, Alex. I think that's a really good question. And what we're seeing in the wake of Dobbs is, federal agencies kind of fill the void where Congress has not acted. So we've seen, for instance, HHS propose changes to the HIPAA privacy rule to limit some aspects of law enforcement's access and ability to access the medical records that are kept by your doctor or your insurance company, any of those HIPAA covered entities. So I think what the question was, do we think that those agency actions like what we've seen in HHS will ultimately lead to legal challenges? And if those actions are permissible under the current authorizations and the current statutory authorities of those agencies. I mean, I think HHS is well within their statutory authority to propose the changes that they've outlined in their most recent notice of proposed rulemaking. Again, that's the rulemaking that was filed in April, and that CDT, in addition to close to 26,000 other folks, have submitted comments in. Having said that, I wouldn't be surprised if, should the agency go forward with a rulemaking pursuant to the notice they put out, I would imagine that it might be the target of litigation. How that ultimate litigation will proceed and play out is going to be highly fact specific, depending on what the challenge is. But given how polarizing reproductive health and abortion is, it would definitely not surprise me to see litigation result from agency actions like what HHS has taken.
And I'll just say, as far as the idea of federal aid, we don't really see any federalism or overreach issues there, because pretty much all the issues we're talking about are deployment and use of federal personnel. So the resources I mentioned, the National Domestic Communications Assistance Center, that's entirely staffed and run and funded by the FBI. Regional Computer Forensic Labs, staffed by the FBI, and what has been proposed is kind of limiting what cases FBI staff can work on. The Computer Analytic Response Team, that's an FBI unit. So we're talking, pretty much just about the field of how can the federal government deploy its own staff, what cases can they prioritize or deprioritize. I think there's no real question that that's within the federal government's purview. When we looked at this issue, we had federalism in mind and wanted to carefully tailor it. That's a reason why we didn't really talk about, well, what if we cut off, all law enforcement or state or aid to a state if the state, prosecuted abortions. That would run into a federalism buzzsaw. And there's a reason why we're not proposing, we're focused on that. We're focused on where the federal government has very clear authority to cut off this aid, because it is just federal delegation of its own resources.
Great. Thanks, Jake. All right. So next question. There has been some discussion over whether social media companies should encrypt user data to the point that they cannot access it to answer a subpoena from law enforcement. Is this a viable option for social media companies seeking to protect data from law enforcement?
In general, yes. I mean, the kind of basic answer I always give to companies asking for more information on this field is you cannot hand over what you do not possess. And, if data is encrypted, yes, you can say, like, I have the encrypted data, but you cannot, if you are not able to decrypt it, if you do not have the content of communications or relevant data in unencrypted forms, the maximum degree you can comply with an order is limited. Now there's encryption is not a one size fits all thing. So I think it's important when we talk about this to, point out that you want to have full encryption and end encryption, encryption through backups in the cloud, which is an issue we've talked about in various areas in the past. So yeah, I think it's important to be precise about kind of what we mean when we say encrypt data in those spaces, and that it is actually fully blocking it off from company access. But in general, that is a very effective way to limit what companies are able to turn over.
All right. Thanks, Jake. And then a few more questions. So one, how do the pushes for a national privacy framework play into this issue? And two, many of these data privacy efforts are narrowly tailored around protecting health data specifically, and even more specifically, health data in abortion-related investigations. The Facebook Nebraska case and the history of the types of law enforcement requests tech companies get show that law enforcement are not seeking just health data, but messages, emails, and location information. Are the health-specific data privacy efforts that some states like California have passed effective in that case? And are there any successful efforts to use the Dobbs decision to push for wider privacy protections that protect those seeking abortions and everyone else?
Sure. So I'm happy to take a first cut at this, and then Andy, you should feel free to jump in too. So absolutely, the push for a national federal privacy law would help protect people's health privacy across the board. And that includes both reproductive privacy, but also mental health privacy, all of the different ways in which we're seeing information about people's health being collected, sold, shared, used for targeting purposes. And for many of us, that's a big motivation to pass this law. You know, one of the things that we worry about is just how easy it is to capture and collect people's health information or inferences about their health. And there's been a big push around that. Again, I think the frame tends to be broader. So we've seen really important reporting recently about how data brokers, for example, collect profiles on people, you know, defining them, whether they have depression or ADHD or whether they are an elderly person, again, being used for ad targeting purposes in a way that many people find patently offensive and can lead to run-on harm. And the reproductive privacy is just an even clearer, more specific example of the downstream dangers of this type of widespread data collection and inferences that can be made about people's health and healthcare choices. So the think of it as general purpose privacy laws. They're protecting people's data, including, you know, whether you visit a religious site just as much as whether you visit an abortion clinic, and all of those things deserve privacy. Those efforts continue. The push for federal privacy legislation continues and is an active debate right now. Many of us watching, in particular, the House Energy and Commerce Committee to see whether they move forward. But what we see is some of the more tailored interventions that we've talked about, like the SHIELD laws, is kind of states trying to step into the breach in the interim. So we need kind of people's private information protected across the board, but then also we can have targeted interventions to try and get at some of the root causes and create particular buffers for medical information, for example, when it is being sought through law enforcement. So we view these two things as complementary to each other. We want the baseline protections for all type of sensitive information. And then personally, you know, we are supportive when states then try and take extra targeted measures to try and create heightened protections in these very sensitive areas where we know that there are going to be cross-state prosecutions, for example. Andy, do you want to jump in on that?
Yeah, and I'll just build on that and talk about kind of the second element of the question that you teed up, because I think Alex did a great job answering kind of the general contours of federal privacy legislation and how that's implicated. But in terms of kind of the universe of data that is being, or that is potentially implicated by state level law enforcement seeking to initiate or you know, investigate people for abortion related offenses, like the universe of data is very large, right? Not only is it kind of the data that is facially, you know, health data, right? Like things like if I'm using a period tracking app, right? That seems pretty probative into, you know, your reproductive health history. But other data points that might not facially appear to be health data, nonetheless, when used in certain ways, can be equally as probative into somebody's reproductive health. Things like location history, right? If my location data is stored in a way that law enforcement can access, and that location data shows that I visited a certain clinic that specializes in, you know, a certain type of reproductive healthcare, that can be very probative into the current, my current health. The same is true for even non-reproductive health instances. If I'm visiting, my location history reveals that I visit a clinic that specializes in gender affirming care, in HIV treatment, in cancer care, all of that data, even like facially, it's just like a GPS coordinate, when used and analyzed in ways to make inferences about people's health, can be super probative and is warranted of greater protection. So, as Alex said, we've seen lots of states take many different approaches to this, especially states that are seeking to instill protections for their residents against states that are going to be coming to them for information regarding reproductive health prosecutions. We continue to evaluate those state laws, and Jay can talk some more about kind of the specific elements of some of the shield laws themselves. But generally speaking, it's good to see the states doing this. It would be great to see, our federal legislative bodies like Congress, the House and the Senate, take up some of these bills, not just ADPA, but there are sector-specific bills as well that would do more to capture the data sets that we're talking about, make them more private, make them more off limits to law enforcement access, and frankly, just encourage companies to collect less of this data in the first place. I won't go too far into that because I think I'll stray into some other questions, but one of the other elements that we've been working on here, and that Jake and my team complement one another on a lot, is that whereas we can put a lot of shield laws in place that limit the ways law enforcement can access data, another element of this is to encourage companies in their corporate data practices to not collect as much data and only collect data that's relevant to the product or service that a customer is directly requesting. And then when that service is no longer necessary, to get rid of that data. That makes it so that when law enforcement comes asking companies potentially for data regarding reproductive health investigations, sometimes the answer will just be, thank you for asking, we have nothing in response.
Yeah, and so I'll just talk a little bit about the shield laws. I think one thing that's very valuable about these is that they are neutral in terms of what kind of data is being asked for and what crime is being investigated. The two of these laws, California and Washington, they have basically as a method for enforcement something called an attestation requirement, which means any warrant or subpoena that goes through to a company, regardless of what it's about, just as a blanket now, has to come with an attestation that the request does not relate to an investigation about reproductive health care. So that's meant to solve this issue of, as Andy highlighted, that, so much of the time we're talking about that data that isn't health data or information on its face, but can be very revealing of private medical and health activities. It also goes back to what Alex said before, is that most abortion investigations are not prosecuted under a statute that just says it is unlawful to get an abortion. They're prosecuted under facially neutral statutes like homicide, child endangerment, child neglect, unlicensed medical practices. So in the case that a company is getting, requests for data that's under one of those laws that might have nothing to do with an abortion, for data that, could have nothing to do with reproductive health care, they're still at this baseline, a very standard attestation question that comes in, which is, does this case have to do with reproductive health care? Cut aside all those factors, just yes or no. And that, we think, is a pretty effective filter for trying to suss out, when those cases are actually about it. So we think that's a very important feature of those laws. And the Washington law in particular, I'll highlight, actually attached a penalty of perjury to that, meaning that, any evidence that law enforcement got if they lied on that attestation would potentially be the fruits of unlawful activity. So I think that's a pretty effective safeguard there.
All right, thanks, Jake. So next question. So the larger conversation about data privacy at the federal level targets how the patchwork across the country of privacy laws doesn't effectively protect Americans. With hyper-specific laws targeting specific types of data, basically health data, what are the potential issues with these clashes at the state level? And then another question around state laws. Could you talk more about privacy-focused state law proposals? Some bills are seeking to protect abortion-related communications like texts or messaging apps, while others are aimed at records like license plate snapshots or geolocation history. So what do you think about the potentially wide range of data that might be swept into abortion investigations, and how much would an abortion seeker's privacy rights depend on what state they're in?
So I'll take a first stab at this, and then my colleagues, please weigh in. No, these are great questions. And I think, you're right to identify that we do have, we've seen states basically in the wake of Dobbs go in two main directions, right? You have states that are hostile to reproductive rights and are passing statutes to further criminalize access and providers of abortion services. And you have the other set of states that are moving more towards enacting shield laws, laws designed to better protect their constituents' data from being accessed from out of state, especially states hostile to reproductive rights. And this is what states do, right? This is the federal system that we've always had in the United States, where you have states are able to, this is the system of federal versus states' rights that we always see play out, where you see states are sometimes more nimble and more active and able to pass laws quicker than the federal government, and you do create potentially some inconsistencies, or you see different approaches taken by states. I think that's what we're seeing right now, especially in states that are trying to enact laws to better protect their constituents, especially their constituents' data. And I think there's a lot of good things we can garner from those. I think there's lessons we can learn from those different approaches. We can see which approaches in practice work better than others. That will take a little time, but those laws can also help inform what we potentially do at a federal level. Like I've outlined before, we've already seen agencies take action that parallel some of the actions that we're seeing at states to better protect data from law enforcement access. But ultimately, CDT has embraced federal privacy legislation at the federal level, and specifically the American Data Privacy and Protection Act that was introduced last year, ADPA. As Alex already alluded to, that bill would go a long way to resolve some of the potential conflicts that we see at the state levels, but it would do a great job at raising those baseline privacy protections for everyone across the country. So it wouldn't be a resident of Virginia would have slightly different data privacy protections than a resident in Maryland or a resident in the District of Columbia would. That's what those federal rules would do. It would set those baseline protections. And one of the debates around ADPA is it setting the floor or the ceiling for those protections? I think you'll continue to hear some of that debate play out when we hopefully see ADPA reintroduced. But that's what those federal privacy laws like ADPA do. They set those at least minimum baseline protections that raise protections for everyone across the country, regardless of what state you're in.
All right, great. Thanks, Andy. So in terms of federal privacy regulation, is CDT supportive of federal legislation preempting state law to protect sensitive data? Or would it be better for federal legislation to create a national floor that states can add additional protections to if they see fit?
I'll jump in on this. Andy, you just teed it up very well. So CDT has always said that there are benefits to having a single national standard. Technology operates across state borders. Consumers move and get information across state borders. But it is only worth it as a compromise and as a deal if the protections for users are very strong. So for us, it really depends on what that national standard is going to look like, and only if it is securing a very high bar of protections for people's sensitive health information and sensitive information across the board, that we think then it might warrant the conversation around preemption as part of a political grand bargain. But the idea of a federal law that preempts, that creates, low protections and then preempts states from protecting their citizens further would be deeply problematic and not something that we would endorse.
Okay. I don't see any other questions.
We had one more about how can people help themselves.
Yes, we did. Okay. So let me just, okay. All right. So we talked about the best practices companies should implement to protect people's reproductive data. So what kind of actions do you recommend to individuals looking to secure their own health data privacy?
Sure, happy to jump in on this one. There's some news you can use, which readers always like to receive. I will say that as an advocacy organization, we believe strongly that the burden should not just be on users. In today's day and age, it's actually impossible for users to carry the burden of protecting their own privacy, which is why we have to have baseline protections and demands from the companies themselves. So the first thing that consumers can do is use the power of the purse. Look for companies that are actually pledging to respect your privacy, that are saying so very directly, so that those promises can be enforced. And then there are a couple of kind of very specific tips that we give people. One is to check your general device privacy settings. So making sure that location data is only being collected and shared when necessary for a particular app to function. If you're going to a sensitive location, don't bring your phone at all. You want to check what apps have access to your microphone, your photos, your camera. And then also it's possible in kind of all phones to check your settings to limit personal ads, which can be helpful because it limits the ways that companies can connect your location, search data, and browsing history, including across devices. Another thing that's useful for people to look at is encrypted messaging and ephemeral or disappearing messages. And then also looking, if you're looking at a browser or an online search engine, finding ones that are trustworthy and really lean into their privacy promises to their users. It's important for people to know that just putting something in incognito mode doesn't make it private. That often limits the how long they keep the browsing history, but it doesn't necessarily make you anonymous to the websites that you visit or to your internet service provider. And then, around period tracking apps and kind of the types of repositories and kind of online journals where people keep information, there's a whole set of recommendations you can make there, looking again for the companies that really lean into their privacy promises, that let people have an anonymous account, considering, of course, whether you need to use the app at all, and then looking for ones where it is easy to delete your records, including making sure that your records are stored on your device, not on the cloud, so that you know that when it's deleted, it is well and truly deleted. Those are all some tips. There's a phenomenal resource out there run by the Digital Defense Fund that is always worth linking to if you're covering this in a story. They have really accessible infographics that help people kind of know how to protect their rights. And again, if you can do us advocates a favor and always include that it shouldn't just be on the users to protect themselves, we need the companies to step up and do their job too. That would do a good service to the community because it's an important piece of the puzzle.
All right. Thank you, Alex. I officially do not see any more questions. So I think we can actually go ahead and wrap up a little bit early. So again, thank you so much to everyone for joining us today. Thanks to Alex, Andy, and Jake for their commentary. And just to remind you who you heard from. So that's Alexandra Givens, CDT's president and CEO, Andrew Crawford, Senior Counsel with CDT's Privacy and Data Project, and Jake Laperruque, Deputy Director of CDT Security and Surveillance Project. All right, so Alex, Andy, and Jake will be available for comment on the topics just discussed following the briefing and in the coming days. So please feel free to reach out with any inquiries to me and the rest of the CDT press team at press@cdt.org. Thank you and have a wonderful rest of your day.